discussion?
Good morning. Push. Mic test.
Good evening, Council, with the court, welcome. The matter before us is a matter concerning the alleged violation of human rights between Kingdom of Ahaba and Republic of Zangi. Allow me first to introduce the bench, then thereafter we'll be inviting the counsel for the applicant to introduce his or her team. So very briefly, my name is Dr. Ebu Situn. I'll be the presiding judge. I hand over the mic to my learned judges.
Good evening. My name is Shalini Awera, judge of this court.
Good evening. My name is Talani Kesa, a judge.
Good evening. My name is Franklin Chilibet, member and judge of the tribunal.
Good evening. My name is Tali Israel Tali, member and judge. Thank you.
Very well. In the interest of time, we are gathered here for the finals, and I wish to welcome counsel for the applicant, which I believe is already predetermined. To make their submission.
Issues before we proceed to the substance of this matter.
Thank you. Your Excellencies, the jurisdiction is a threshold question. Without it, the merits of this case cannot be whispered. The respondent contests the jurisdiction of this court. Therefore, Your Excellencies, on the same, we submit that this court lacks jurisdiction to hear and adjudicate on this matter because the jurisdiction of this court is limited to interpretation and application of the treaty and not on human rights violation. Article 27, Sub-Article 2 of the East Panarian Community Treaty provides that this court the jurisdiction of this court on human rights shall only be extended upon the operationalization of a protocol contemplated in the same article by the Council to the East Pandaren community. It is the submission of the respondent to date. There is no protocol to extend this court's jurisdiction to human rights, and therefore we submit that this court lacks jurisdiction on issue number 1, issue number 2, and issue number 4. Your Excellency, this court, the appellate division of this court in Attorney General of Rwanda versus Praxida Rugunda held that a cause of action must emanate from the treaty in order to peg the jurisdiction of this court other than human rights violations. Your Excellency, issue number 1, issue number 2, and issue number 3 is human rights violations. We contest the admissibility of issue number 3 as a purely political matter. Your Excellency, use of military groupings is not just about intellectual property. It is about military balance of power and strategic advantage between states. And therefore, the matter is political, and actually the proper organ to adjudicate on issue number 3 is the summit established under Article 9 of the East Pandaren Community Treaty. And therefore, this court lacks the jurisdiction to continue.
Very well, Counsel. The respondent, you wish to respond to the same?
Much obliged. Now to respond on the preliminary objection to the jurisdiction, it is the position of the applicant that this court has the requisite jurisdiction to hear and adjudge the present disputes raised before this court pursuant to Article 27(1) of the East Pandaren Community Treaty, herein after the EPC Treaty, which vests this court with the requisite jurisdiction to hear and adjudge matters pertaining to the interpretation and application of the EPC Treaty. Members of the bench, Article 6B of the EPC Treaty provides for the tenets of good governance, to which it includes the protection and recognition of human rights, therefore making the matters and the claims raised before this court squarely within this court's jurisdiction. And in any case, the applicant persuasively relies in this court's decision in the James Katabavazi versus Secretary General of 2007, where this court stated that although it does not have the jurisdiction to entertain matters of human rights violations per se, it has the jurisdiction to interpret matters to do with the violations of the EPC Treaty, even when the matters raised includes human rights violation. On to matters locus standi, it is the position of the applicant that all the claims raised before this honorable court are admissible. And for that, the applicant would like to cite Article 103 of the EPC Treaty, which recognizes the fundamental importance of science and technology in the economic development of partner states. And under the Berne Convention, Article 2(1), the definition of literary and artistic works extends to science, and the blueprints represent the practical application of scientific and engineering knowledge, for instance, architecture, physics, and material science. This is the response of the applicant.
I'd like to clarify a few issues. But first, to start with the issue that you've just finished with, you've cited the Berne Convention. Your first argument was Article 27 allows this court to interpret the treaty. Does the Berne Convention fall within the applicable law that this court can interpret?
Much obliged. And to respond to your question, I would like to guide this bench to paragraph 7 of the facts, which indicates that both parties before this proceeding have ratified the Berne Convention. Therefore, the provisions of the Berne Convention are binding to both parties and can be considered by this court for interpretation in the aid of interpreting the EPC Treaty.
So under the treaty, is there a provision that allows this court to interpret the Berne Convention? And which provision is that?
Much obliged. no, there is no provision under the same. However, this court, in the same case I had cited earlier, that is the James Katabazi case, the court held that the parties can rely on international instruments to aid in the interpretation of the treaty.
Good. Now, my question then was on two issues. Number one, considering that these issues here, issue A to D, were issues that had been submitted before the High Court in the respondent state, so does this court sit as an appellate court, considering that these issues were already addressed by the High Court and you never appealed the same?
Much obliged. And to respond to your question, the applicant before this court is the Kingdom of Rahada, which is not an organization or a citizen of the Republic of Zangi, and therefore it could invoke this court's first instance jurisdiction to bring the claims before this court, especially since the local standing of the applicant is provided for under Article 28 of the EPC Treaty, which provides that a partner state can bring another partner state can invoke this court's jurisdiction, or can rather refer to this court for adjudication where they find that another partner state has failed to fulfill their obligations under the treaty.
Okay, proceed.
I have a question for counsel for the respondent. You are arguing that this tribunal lacks jurisdiction. However, the applicant argues that there are not only human rights matters in violation, there is additional arguments such as principles of good governance, accountability, and rule of law. And those are enshrined under the East Pandarian Community Treaty, which this jurisdiction has tribunal. So first, how do you respond to that? Secondly, are you familiar with the case of James Katabazi versus Secretary General of East African Community, case of 2007? And do you distinguish this case from that Katabazi case?
Thank you, Your Excellency, for your question. I'll answer it in this way. The James Katabazi case versus the Attorney General of Uganda was decided in the year 2007. I have quoted the decision of Attorney General of Rwanda versus Plaxeda Rugumba, which was decided in 2011. And therefore, the decision in Plaxeda Rugumba has a more value than the decision in James Katabazi. Your Excellency, the court in Plaxeda Rugumba held that it will not, while it will not abdicate its duty to interpret the treaty under Article 27, under Article 27.1, it will not leave out on adjudicating on the same, even if the reference includes issues of violations of human rights. But in appeal, the court clarified that even if there is issues of human rights which the court might assume jurisdiction, then there has to be a cause of action that emanates strictly from the provisions of the treaty in order to peg the jurisdiction of this court. And therefore, it is upon the applicant to peg these issues to provisions, particular provisions of the treaty, in order to invoke the jurisdiction of this court.
They have picked the same on Article 27, Article 6D and 7.2, and she has submitted that the court has jurisdiction to interpret the treaty. When you go to Article 6D and 7.2, the treaty provides for good governance, for protection of human rights. So if a state violates human rights, it is something that directly emanates from the treaty. And this court has times without a number adjudicated on human rights claim. Most recently, in Martha Karua versus Attorney General of Kenya and two others, this court held that the rights of Honorable Martha Karua had been violated. That is extremely as recent as 2023. So why would this court take a different approach from the approach that we took just 2 years ago?
Your Excellency, on the same, I seek to guide this court that Article 27 provides, Article 27(1) provides that this court has jurisdiction on the interpretation of the treaty. Article 27 sub-article 2 limits this court's jurisdiction on the interpretation of the treaty and says that this court will assume jurisdiction upon the operationalization of a protocol to extend the same. And therefore, on Article 27, this court lacks jurisdiction. Your Excellency, on the question of the case of Attorney General of Kenya versus Martha Karua, a decision of 2021, Council seeks to distinguish that case. Your Excellency, the case of Martha Karua went from the High Court of Kenya to the Court of Appeal of Kenya, to the Supreme Court of Kenya. The Supreme Court issued a decision as the final court in Kenya, and therefore Martha Karua pursued the East African Court of Justice to seek certain remedies against actions of the judiciary of Kenya as an actor of state. Your Excellency, in the present case, these are mere human rights violations. There is no, and therefore the decision in Martha Karua does not apply in the matter at hand.
You submit interesting that these are mere human rights violations. Do you retain that position?
Your Excellency, thank you for that guidance. Yes, it is issues of human rights violations. We do not take a dim view of human rights issues.
So are you saying that without the operationalization of the protocol under Article 27, this court cannot adjudicate human rights violation claims?
Your Excellency, on your question, it is instructive at this point to examine Article 31 of the Vienna Convention on Treaties. Your Excellency, Article 31 of the Vienna Convention on Treaties provides for how treaties should be interpreted. Treaties should be interpreted in good faith, in ordinary meaning, in context, and within the object and purpose of the treaty. The drafters of the East Palestinian Community Treaty did not intend to extend the jurisdiction of this court on human rights until the operationalization of the protocol on the same.
Counsel, you are aware that we are not bound by our decisions, correct?
Yes.
So we can very well rule on this matter without due regard to previous decisions by this tribunal.
Your Excellency, to answer your question, in line with the oxygen principle and the inherent powers of every court, then this court has the powers to determine its jurisdiction on every particular issue.
Thank you. And then lastly to counsel, you mentioned Article 27, and Article 27 is also clear that the treaty allows for other jurisdiction like human rights, as will be determined by the council at a suitable subsequent date. Can you please point exactly when this determination or decision was made to allow us grant jurisdiction?
Just to seek clarification, Your Lordship, are you referring to Article 27(2) of the APC Treaty? Much obliged. Indeed, the applicants do recognize and acknowledge that Article 27(2) of the EPC Treaty extends this court's jurisdiction to human rights violations only after a specific protocol has been passed. However, members of the bench, allow me to reiterate the position of the applicant by stating that Article 6D and 7(2) of the EPC Treaty provides for the tenets of the principle of good governance, including human rights, and the human rights in this case includes the right to freedom of expression, the right to privacy, the right to access to information, and the right to protest, members of the bench, and therefore it falls expressly within this court's explicit jurisdiction.
Very well, counsel. You may have a seat. Having listened to both parties on the issue of jurisdiction, we've consulted as a bench, and we therefore rule that this court has jurisdiction to your matter. And that is the ruling of the court. We may proceed.
Thank you, President Judge, Your Lordships, Your Ladyships, and counsels for the respondent. Good evening. My name is Zarina Chentai, and appearing alongside me is my co-counsel Ashel Mwendi. Together, we represent the Kingdom of Bahada, the applicant in the present proceeding. For For the 30 minutes allocated to us, I intend to spend the first 15 minutes to address the issues of merits A and C. My co-counsel will address the merits of issues B and D for 13 minutes, and we reserve 2 minutes for rebuttals. With the leave of this court, I request to proceed.
You may proceed, counsel.
Your lordships and ladyships, by suppressing the freedom of expression and protest, conducting unlawful surveillance, and misappropriating the Hada's intellectual property, the respondent state has demonstrated a deliberate assault to fundamental rights and international obligations. Your honors, to excuse Zangi's conduct will be to legitimize repression. To condemn it is to uphold the rule of law and human dignity. On to the first issue tabled before this court, it is the position of the applicant that the government of Zangi violated the rights to freedom of expression, media and protest by shutting down internet access and by dispersing, injuring and arresting protesters. This position will be canvassed in two limbs of arguments. First, that the respondent violated the right to freedom of expression and media. Members of the bench, kindly move with me to paragraph 19 of the facts. It indicates that Mwana Mwengi planned a second protest. This is after an uproar in the CAIB platform with regard to the leaked list. Now, under paragraph 25 of the facts, on the day of the protest, millions of Zangians woke up to no internet access, leading to no communication on both social media platforms as well as broadcasting channels. This, members of the bench, is a violation of Article 19 of the International Covenant on Civil and Political Rights and the Universal Declaration of Human Rights, which provides that every individual has the right to freedom of expression. Now, the applicants do acknowledge that this right is not absolute and therefore subject to limitation within the confines of Article 5.2 of the protection of the International Covenant on the Protection of Journalists, as well as Article 19.3 of the ICCPR, which provides that the rights to freedom of expression can be limited for the purposes of national security and public order. In persuasive reliance in the case of Konate versus Burkina Faso of 2014, before the African court, the court at paragraphs 125 to 154 held that for a right or a fundamental freedom to be legitimately limited under the law, then it has to meet the three pass test of legitimacy, proportionality, and necessity. The applicant is no contention of the legitimacy test, since Article 19.3 provides for the limitation and the grounds in which the limitation can happen. However, members of the bench, what is in contention is the necessity and the proportionality of this internet shutdown. And the applicant is cognizant of the fact that for a limitation of a right to be necessary and proportionate in a democratic society, then it has to be relevant to the legitimate purpose the state wishes to protect, and it has to be the least restrictive means for the achievement of that purpose. The applicant asserts...
Counsel, question. I'm really disturbed. So you are saying that you're trying to tell the respondent state how to interpret the internal laws, or what proportionality is, what legality is. Is that what you're saying?
Much obliged. No. What you are trying to do, members of the bench, is to call out the actions of the respondent state, which violates its people's right to its people's enjoyment of right to freedom of expression.
But why don't you let their people, fight that fight? Why do you have to intermeddle in the internal business? Much
obliged. The rights being addressed here, members of the bench, goes to the Article 6D of the EPC Treaty, which in turn shows the violation of the principle of good governance and rule of law within the state and the Republic of Zangi.
So, but don't you think it's an overstretch for you to go and talk about whatever is happening in their country? Don't you think that's a bit of an overreach?
Much obliged, Your Honor. no, this is not an overbridge, since it is very evident that the courts within the Republic of Zangi have not proved to be effective, and in any case, the applicants or the parties before this court did not prove that they exhausted any local remedies before approaching this court.
Very well. Then lastly, let's talk about, you said that this right is limited. You agree the right is limited. And so what is a test for the limitation of that right? And has this case met the threshold for the limitation of that right?
Much obliged. To respond to your question, the applicant persuasively rely in the case of Kahiu versus Mutua of 2016 before the High Court of Kenya, where the court, in interpreting the provisions of Article 24 of the Constitution of Kenya, held that for a right or a fundamental freedom to be limited or lawfully, then it has to meet the three-part test of legitimacy, proportionality, and necessity. Now, in the present case, the legitimacy test is not in contention. However, the necessity and proportionality test is what is concerning members of the bench. The applicant has said that contrary to the respondent's assertions of protection or prevention of public disorder under paragraph 27 of the facts, which legitimized, according to what the respondents are arguing under paragraph 27, is the reason or the ground for the internet shutdown, is a blanket blackout, and which indiscriminately curtails the rights of millions in their exercise of the freedom of expression to the extent that isn't provided by law. In any event, members of the bench, the respondent has failed to provide evidence of unverified content being broadcasted by broadcasting channels, neither have they provided any evidence of inflammatory content to justify public disorder matters.
Counsel, you mentioned that they haven't provided evidence of any inflammatory remarks. Therefore, you acknowledge that the reason for the shutdown was possibility of inflammatory remarks, correct?
Much obliged. No, member of your lordship, because even in the concurrent happenings or even in the past happenings, there has been no imminent threat of matters to do with national security or public disorder matters.
Let me walk with you through the fact pattern. There is somewhere in the fact pattern where they say, I think we want their blood or something. There are such statements in the fact pattern, correct?
Come again kindly.
Is there somewhere in the fact pattern where they're talking about statements such as we want their blood? I saw
Yes,
it somewhere
indeed.
in which paragraph? So that
Paragraph 13.
13, huh?
Yeah.
They must pay in blood, correct? That you would agree would be an inflammatory remark. But most importantly, what I want to assess is necessity and proportionality. And when you look at paragraph 25,
Indeed.
and then when you go to paragraph 27, even the media channels, there was a letter that was sent to them giving them prior notice. And then at paragraph 27, we are told the measures that were taken were temporary measures. Don't you think that it's within the right of a state to take such action to protect its citizens and property? Would that not be proportional and necessary? And if that is not proportional and necessary, what is?
Much obliged, and we do note your concern, your lordship. However, allow me to rely on a case whose facts are similar to the present case. That is the Amnesty International Togo versus the Togolese Republic of 2020 before the ECOWAS court. Now, in this case, members of the bench, the Togolese Republic conducted an internet shutdown on the day of the protest, which was also termed to be temporary. And this was during the 2017 protest. Now, the ECOWAS court, in its finding, stated that the generic shutdown of internet and social media platforms preventing innocent individuals from lawfully exercising their right to freedom of expression and information could not be necessary and proportionate necessary and proportionate response. Now, in another case, members of the bench, the Media Monitoring Project versus the South African Broadcasting Channel, where the facts are also similar to the present case, the court suggested that a prior restraint be a least restrictive means that the government should have adapted. Now, the rationale under paragraph 18 of this decision was that...
You said prior restraint.
Yes.
What is that?
Under paragraph 18, this was interpreted to mean a ban on a category of a coverage content. The government should have first edited. Members of the bench, the applicant is cognizant and recognizes the provisions of Article 6(b)(1) of the Berne Convention for the Protection of Literary and Artistic Works, which provides that copyright of original works generally belong to the author. However, the applicant persuasively relies on the Kenya Copyright Act, especially Section 31, as well as Section 11 of the Ugandan Copyright Act, which provides that if a work is either commissioned under a contract or created in the course of an employment within a contract of service, then copyright automatically transfers to the commissioner or the employer unless there is a contract to the contrary. This is the cornerstone of the doctrine of work made for hire, members of the bench. Now, in persuasive reliance, in the case of R. Griggs Group Limited versus Evans of 2005, the England and Wales Court of Appeal held that under a commissioning agreement, an implied term exists in the contract vesting full beneficial ownership of the copyright in the commissioner. Now, similarly, members of the bench, under paragraph 29 of the facts, General Mahmoud Ali was contracted by the Kingdom of Rahada, and under the contract, it raises an implied obligation or an implied term that arises under the contract vesting full beneficial ownership within the Kingdom of Rahada. And in any case that this court finds that General Mahmoud Ali was an independent contractor and therefore retains his copyright rights.
Counsel, was this a contract for hire or a contract for service, or was it a contract of service? And how do the two distinguish in this case?
Much obliged. In the present facts and in the present case, members of the bench, there are few facts provided for with regards to the kind of relationship between...
No, I want you to be very direct with the question, okay? So answer it, and then you can give the explanation, okay?
Okay.
Don't start with the explanation because you could easily lose the bench. So was it a contract for service or a contract of service? And then explain.
Much obliged. This was a contract of service because under a contract of service, and allow me to rely in the Marvel Characters versus Kaibi case before the England and Wales Court of Appeal, where it states that a contract of service, it creates an implied obligation that it is a work made for hire agreement between the parties in the contract, and therefore the benefits, the resources and the space and the control is always on the part of the commissioner of the contract, and therefore seeing that the other party within the contract, who is, let's say, General Mahmoud Ali, allow me to retract my statement, members of the bench. Indeed, this is a contract of service.
You only have 30 seconds, so you should be winding up.
Under a contract of service, members of the bench, it creates an employee-employer relationship, whereby within that period of the contract, the contracted person, who is General Mahmoud Ali, will enjoy and utilize the resources of, I request for discretionary 30 seconds to conclude.
Add you 1 more minute.
Thank you. Under this contract of service between General Mahmoud Ali and the Kingdom of Rahada, General Mahmoud Ali utilized that this court grants compensation, first to declare that the Republic of Zangi was in violation of copyright rights of the Kingdom of Rahada, and to also grant compensation to Rahada for the violation of the doctrine of substantiality on the part of the Republic of Zangi.
It's because I'll take you back to your arguments on jurisdiction. You said you are here under Article 27 that allows this court. When this court is interpreting the treaty, I believe its duty is limited to declaring whether there is a violation of the treaty or not. Under that prescribed jurisdiction under Article 27, number one, does the court have powers to order that IP rights have been violated when IP rights are not part of the treaty? And number 2, does the court have the power to order compensation as you pray? And Article 27.
Much obliged. The applicant do note that the kind of remedies that this court can give are declaratory orders, and therefore members of the bench, by virtue of Article 103 of the EPC Treaty, which recognizes artistic works, we urge this court to find that the Republic of Zangi was in violation of copyright rights on the part of the rest of the applicants.
So you take back the argument on compensation?
Yes.
There should be no compensation awarded to you, right? Okay, thank you.
I thank this court for its time, and I cede the floor to my co-counsel to address the merits of issues B and D.
Very well, counsel. May I proceed?
Greetings, honorable members of the bench, and may it please this court. As earlier introduced, my name is Lashelle Muindi, second counsel for the applicant, and to converse on issue B and D and state our prayers. With the leave of this court, I wish to proceed. Honorable members of the bench, the case before this honorable court is about people whose privacy was invaded, whose dignity was stripped off, and who were turned into state objects rather than right holders by their very own government. Turning to issue B, on whether the government of Zangi violated the data protection principles by conducting targeted surveillance on activists and protesters, it is the applicant's assertion that indeed the government of Zangi violated the data protection principles of the right to privacy, consent, and data minimalization through conducting targeted surveillance on activists and protesters. Before deeply delving into my substantive argument on issue B, the counsel for the applicant is aware that the counsel for the respondent might argue that the case before this honorable court, that the applicant case rests on speculation. In that case, the applicant persuasively invokes the case Velasquez Rodriguez vs. Honduras of 1988 under paragraph 130 all through to paragraph 131, where the Inter-American Court on Human Rights stated that circumstantial evidence, patents, or reasonable inference is admissible and enough and attributable to a state where the state fails to explain events occurring under its tolerance. Honorable members of the bench, move with me to paragraph 24 of the fact pattern, which showed that the Inspector General of Police, a state officer, was being very economical with the information he offered as he failed to offer information about the increased cases of abductions. Having established that, the counsel for the applicants turns to the violation of the data protection principle of the right to privacy. Honorable members of the bench, privacy is neither a gift nor a privilege from the state. It is a guaranteed right enshrined under a conjunctive reading of Article 17 of the International Covenant on Civil and Political Rights and Article 12 of the Universal Declaration on Human Rights, which prohibit arbitrary interference with private life, correspondence, and communications. Yet the government chose to secretly tap into the government records, phone conversation, and the Google search histories of activists and protesters. Honorable members of the bench, the applicant is aware that the right to privacy is not absolute. However, the limitation to this right must meet the three-part test of legality, necessity, and proportionality. The applicant is not in contention of legality. What the applicant contests is necessity and proportionality. Honorable members of the bench, necessity demands that the measures used by the state be ones that respond to a pressing social need. In this case, national security and public order as the respondent's claim. Honorable members of the bench, move with me to paragraph 23 of the fact pattern, which show that Barely 40 minutes after Mwalimu Abdi had posted a video criticizing the government, he was forcefully captured. Honorable members of the bench, this shows that the government's true aim was not to protect and preserve public order as it had stated. Rather, it was to silence and suppress the dissemination of information. Honorable members of the bench, proportionality as established in the case Okiya Mutata vs. Communications Authority of Kenya under paragraph 100 a case of in 2018 requires that the least intrusive option available be used. Honorable members of the bench, Zangi had alternative lawful avenues like deploying officers at protest sites, coordinating with protest organizers, or seeking judicially supervised warrants. Honorable members of the bench, the state resorted to extreme measures of secretly monitoring, abductions, and forced biometric data collection.
Council, allow me to interrupt you a bit and to take you back to your three-part tests. Number one was legality, and you said it is not contested, right? Why?
Honorable, thank you very much for your question, my ladyship. Legality is not in contention. The applicant is not in contention of legality, as Section 36 of the Kenya National Intelligence Service Act does authorize interception of information. Therefore, the targeted surveillance or interception with private communications is indeed provided by the law.
Question. Where do you get the evidence that these violations happened? Which is your source of evidence?
Thank you very much for your question. The applicants asked this court to see that the reasonable inference in this case, the reasonable inference in this case, which may amount to circumstantial evidence.
Okay. So it is an inference, and it is circumstantial. So do you have any solid evidence that in fact the government did what you are alleging that they did?
Have you very much for your question, Honorable Judge. As the counsel for the applicant...
No. So first answer yes or no and then explain, okay? So do you have any hard evidence of the allegations against the government?
No, Honorable Member of the bench. However, the counsel for the applicant persuasively invokes the Velasquez-Rodriguez vs. Honduras.
No, but you see, this is not a legal question, it's a factual question, right? And so I'm expecting a factual answer. And I'm asking, do you have any evidence that your allegations against the government are actually solid? There have been, you know that there are cases where people could easily abduct themselves and, fake things for fame. So how do you not know that this is not one of those instances?
Honorable Member of the bench, I do take note of your concern and much obliged. Paragraph 23 and 24, all through to paragraph 28, show that immediately after the abducted persons were found, they all presented that, or rather they all said that there was forceful biometric collection. Honorable Member of the bench, this cannot be mere coincidences. They are all attributable to a certain entity, and in this case, the Inspector General of Police, and I had stated earlier, who is a state officer, remains silent on the increased cases of abduction, and therefore, it is the applicant's assertion that the state is attributable for the actions.
Just a logical question I'm thinking about. You're saying the biometric data of these persons was collected after they had been allegedly abducted, correct? So why would the state need such kind of data? If the intention was to abduct the people, it has already abducted them, correct?
I beg your pardon, Honorable Member of the bench.
You are saying that the biometric data was collected after the alleged abductions. And that is paragraph 24, correct? So I'm asking if the intention of the state was to obtain this data and target these persons, why will it need the data after the individuals have already been abducted? What was the purpose of the data? We are trying to see who to believe. Do we believe you or do we believe the Inspector General?
Thank you very much for your concern, Honorable Member of the Bench. It is the applicant's assertion that yes, indeed, if the government really had the intention to, if the government really conducted targeted surveillance on the activists, then why was there a need for the biometric collection to be collected? If I've got you right, that is your question. Well, Honorable Member, it is not, the applicant submits that these were different occurrences, that the targeted surveillance occurred and then later people were abducted, and in the course of the abduction, the biometric data was collected. The applicant has pointed towards this to form a reasonable and coherent inference that this can be attributable to the state, Honorable Member of the Bench.
And then I note that you're using the word targeted surveillance, meaning it was not blanket surveillance on everybody. It was surveillance for specific purposes, correct? Doesn't that fall within the limitations of proportionality? Because they're not surveilling everybody in a blanket manner. They're only surveilling targeted individuals. And then when you look at paragraph 24, the Inspector General says there was intelligence that they received concerning planned schemes of destruction of property and theft of resources. That one already obligates the state to take some measures, correct? So, and then you're saying it's targeted, it's not blanket. Doesn't that fall within the exceptions?
Well, thank you, Member of the Bench. And to answer your question, the counsel for the applicant persuasively relies on the implementation guide on the principles of targeted surveillance, where it clearly establishes the due process of the government, or rather it stipulates the process that the government is required to take in matters of targeted surveillance. One being, in cases which are not emergency cases, the government is required to issue a request for a warrant from the judiciary, and further, in cases of emergency, as the applicants made claim in this case, and as you've cited, Honorable Member of the Bench, there were destruction of property. In such cases, Honorable Member, the government, or rather the person who is going to conduct the targeted surveillance, is obliged to issue a notice before requesting the targeted surveillance and conducting the targeted surveillance. Having answered the question, it is therefore the applicant's assertion on issue B that the targeted surveillance was unlawful, disproportionate, and unnecessary. Turning to the fourth issue tabled before this court, it is the applicant's assertion that the government of Zangi violated Mr. Mwengi's right to access information by prosecuting him for publishing the lease agreement between Zangi and the Sarabian investment firm. Honorable members of the bench, seeing that my time is far much gone, I seek one discretionary minute to submit and conclude on issue D.
Very well, Counsel. It's allowed. Now you 1 more minute.
Thank you very much for your generosity, Honorable Member of the Bench. Honorable members of the bench, move with me to paragraph 17 and 28 of the fact pattern, which show that Mr. Mwengi was prosecuted for publishing the lease agreement, information of great public importance. Honorable members of the bench, the applicant places a persuasive reliance on Principle 2 on the principles of the right to information as read together with Section 51C of the Kenya Access to Information Act, which oblige states to publish information relating to public spending, management of its resources, and public contracts. Honorable members of the bench, the Rahab Port and Mafuli Goldman lease was information involved the alienation of public property, which is information of great importance. By concealing this agreement, the state breached its transparency obligation under Article 6 as demanded under Article 6D of the EPC Treaty. The applicant poses one question to this honorable court. If the state genuinely intended to disclose the information, then how proportionate would it be to prosecute Mr. Mwengi for doing the exact same thing?
Let me ask, you look at paragraph 27, 28, he was arrested, then prosecuted for publishing official secret documents, but I suppose that case is still in court because he was released on bail, correct? Don't you think the principle of lis pendens prohibits us from dealing with that matter until it is determined by the local court whether indeed he published secret documents?
I beg a clarification on your question, honorable member of the bench.
I'm saying paragraph 28, he was arrested, charged, and he is out on bail. Is that correct?
Yes.
Meaning that his case is still ongoing in the criminal court. He has not been convicted yet, correct?
Yes, honorable member of the bench.
There is a principle called lis pendens, where a matter is pending before another competent court. For this matter, that is a criminal court. This is not a criminal court. Should in this court first wait for the criminal court to either convict him or acquit him, correct? Before rendering itself. For example, we can make a decision and then he is acquitted in the criminal case. Shouldn't we first wait until the criminal case is concluded?
Thank you very much for your question. And yes, indeed the prosecution of Mr. Mwengi is in continuation, is still ongoing. However, the question in this case is about the violation to the right to access information, honorable member of the bench, which fall under the key tenets of good governance as stated in Article 6D of the EPC Treaty. In conclusion, the Council for the...
Council, I know your time is up, but I really want you to answer me this. The respondents are arguing that the decision to prosecute Mr. Mwengi was on the basis that his right is limited, on the basis of necessity, proportionality, and protection of national security. How do you respond to this? Very quickly.
Thank you very much, honorable member of the bench. The respondent has not shown the actual harm that was caused by Mr. Mwengi leaking the information. Therefore, the respondent is only using abstract fears to economic sovereignty to argue on the basis of national security in relation to economic sovereignty. And on proportionality, the prosecution of Mr. Mwengi was the most intrusive and the harshest possible alternative available, as other measures such as unofficial clarification and as well as disciplinary actions were available. In conclusion, the Council for the Applicant submits that the government of Zangi violated the freedom of expression, media, protest, the right to access information, and data protection principle, as well as intellectual property rights. And therefore, the applicant asks this court to find that to declare that the actions of Zangi unlawful and order compensation and grant compensation to the victims of the targeted surveillance as well as the abduction. Thank you. And
we agreed that compensation cannot be granted by this court.
I retract that statement and
So again, no compensation. Thank you.
I rest my submissions.
Council, while still on your feet, if I may, sorry to take you back, but on the issue of data protection, you mentioned that consent and data minimization were the alleged violated principles. Is it safe now to say that those were the only principles allegedly violated in this case?
Yes, honorable member of the bench, and as consent, data minimalization, and the right to privacy were the data protection principles that were violated.
Are you sure, even looking at paragraph 24?
Yes, Honorable Member of the bench. I thank you for your indulgence. I cede the floor back to the bench for further directions.
Thank you, Counsel. I now invite Counsel for the respondent and wish to guide you that in the interest of time, please respond to the actual issues raised without necessarily deviating.
Thank you. Thank you, Presiding Judge, for that guidance. Your Excellencies, imagine a nation as a fortress, built not to shut the world out, but to protect the people within. Every wall, every guarded gate, every fortress stands not for fear, but for protection. Yet, from a distance, other people might view this vigilance for hostility. With respect to Your Excellencies, my learned co-counsel will address and define what that fortress is. With profound respect, Your Excellency, on record for the respondent is Nathan Mwanja and Ms. Wanjiko Kimani. Having already addressed the question of jurisdiction and admissibility, I therefore seek to proceed to the substance of the matter. Your Excellency, the respondent submits that rights just like fire warm the house when contained, but burn the house when left unchecked. Your Excellency, this case is not just about silencing freedoms. It's about drawing the line where liberty becomes a license to destroy, where protests become perilous. The applicant will have you believe that the Republic of Zangi morphed overnight into a totalitarian regime. With respect to Your Excellencies, that is fiction, not the factual matrix before the court today, and I shall proceed to demonstrate shortly. On issue number one, this court is invited to make a determination on whether the respondent state violated freedom of expression, freedom of media, and freedom of protest. The applicant has submitted that the respondent violated those particular freedoms. Your Excellencies, it is important to note at this point that these rights, though are sacred, they are not absolute. They do not fall within the purview of what is defined as peremptory norms under the jus cogens principles. And therefore, they are limited under Article 19, Sub-Article 3 of the International Convention on Civil and Political Rights, under the Siracusa principle, and also under this court's own decision in Burundi Journalists Union versus Burundi. Counsel for the applicant relied in the Kenyan case of Okia Omtate versus the Attorney General of Kenya. We have quoted the decision of this court, which actually has more value on the question at hand. Your Excellencies, now permit me to address each individual violation. On the question of violation of freedom of protest, Article 11 of the Pandarian Charter on Human Rights provides for this right. Article 21 of the ICCPR entrenches these rights, and they proceed to provide that these rights are not absolute and they can be limited in the interest of the public and in the interest of national security. Your Excellencies, it is important, therefore, at this point to examine the facts in issue. A protest that began in peace mutated into a maelstrom of violence. Goons infiltrated the protest, batons in hands, vandalizing property, beating every and any person in sight. Your Excellency, at that point, the Republic of Zangi was faced with a choice to restore order, a choice to protect property, or a choice to abdicate its duty. The Republic of Zangi chose the lawful path of restoration of order. Your Excellency, counsel for the applicant alluded that these actions were not necessary and these actions were not proportional. On the same issue, Your Excellencies, permit me to guide this court to paragraph 26 of the fact button.
So you shut down the internet, right? Did you shut down the internet in a specific region or the entire country?
Your Excellency, as per the fact pattern paragraph 24, the citizens of Zangi woke up and found that internet was off, and therefore it was for the entire country.
Was there violence across the whole country?
Your Excellency.
Yes or no, Counsel?
Yes.
Was there violence in all cities, all towns, all streets?
Yes.
There was? And where do you get that?
As per the fact pattern, Your Excellencies, Mr. Mwanamwengi plans a nationwide protest.
So, but did it happen in every street in the country?
Your Excellency, Council cannot guide this court on the question because the fact is limited to the protest that happened in Sundown Boulevard town.
Exactly. So let's presume it happened in the boulevard, right? What is the justification to shut down internet in the whole country?
Your Excellency, the right to access of internet, which might enable realization of other rights, is not, access to internet is not absolute. At certain points, the state has the right to shut down the internet in order to safeguard national security and public order.
Okay, proceed.
Thank you, Your Excellency.
Council, you say right to access the internet. Is there a specific right of access to the internet?
Your Excellency, there is no specific right of access to internet, but the United Nations Human Rights Council has held that access to internet is an enabler of freedom of expression and at the same time is an enabler to access of information.
And then now, the question that my co-judge had asked boils on the proportionality. The applicant submitted that the state had the possibility of removing inflammatory content from the internet and leaving people to enjoy the other freedoms. For example, people use the internet for mobile transaction, for business, for other commercial purposes. Was there a need to shut down all these other purposes, or the government could develop an algorithm to specifically shut down only the specific sections of inflammatory content?
Your Excellency, I do note your concern on the same. It was not possible to remove the inflammatory content and leave the others. Remember, Your Excellencies, the Republic of Zambia was faced with a duty to safeguard national security, and therefore it warranted decisive and prompt action. And therefore, at that point, the removing of inflammatory content will take a lot of time. Your Excellencies, also, it is important to note that the Republic of Zambia is a struggling nation, and therefore it does not have the technological capacity to develop an algorithm on the same.
Council, your argument is very disturbing for me. I know people who were in the house on that day playing video games online. I know someone who was trading Forex online. Nothing to do with the protest, but you want to shut down internet in the whole country because of a protest in a specific place. But nevertheless, I mean, I'm really confused. But nevertheless, you still arrest protesters, you send police to beat them up with tear gas, you beat up journalists. This is absolutely disturbing. I mean, how do you respond to these allegations?
Your Excellency, on the allegation of arrest of some of the protesters, as alluded by the Inspector General of Police, is that they arrested the violent protesters.
Then if you arrested the violent protesters, then why shut down the internet?
Your Excellencies, things were happening fast.
Interesting, Council. Council, let's just have some order because his time is running. Let's have order, please. Let's have order for the sake of his time. You can add him a minute for the sake of his time. Now, what I'm interested to know is, was there any inflammatory remark posted on the internet?
Your Excellency, as noted by the Inspector General of Police under paragraph 24, is that they received intelligence that the protests will be violent. And therefore, every action that is being perpetuated to the realization of the violent protest, Your Excellencies, constitutes an inflammatory content. And therefore, that necessitated shutting down the internet.
Put it in a different way. Was the internet being used to mobilize people to come and protest? Or was it being used to mobilize people to come and cause violence in the protests?
Respectfully, Your Excellency, the internet was being used, particularly the CRIBE platform, to organize for the protests. But Your Excellencies, after on the protest day, we realized they turned violent. We acknowledge that there was intention of a peaceful protest, but the same protest turned violent, and actually the intelligence that the police had was that there was a plan for violent protests.
So the internet was not used to call people to cause violence, correct? But then your justification for shutting down the internet is to prevent violence from happening. So it doesn't sit and make logical sense.
Thank you, Your Excellency, for your concern. The internet was shut down because the protesters were planning violent protests, and that is within the knowledge of the...
You're saying protesters were planning violent protests?
Yes,
and I'm asking, according to?
The intelligence report that the police had.
Okay, proceed.
Thank you, Your Excellencies. Having addressed the question of protest...
Please go to your next limb of argument.
Yes,
the next issue, yes.
I'll proceed to the next limb, which is violation of freedom of expression and freedom of media. Okay, thank you for that guidance. I'll proceed to merit 2, which is a question for this court to determine whether the Republic of Zangi violated data protection principle. The applicant cries foul over surveillance, alleging Zangi is a big brother state. But Your Excellencies, let us be surgical with the facts. There is no evidence, only shadows, and a lot of anonymous sources. Article 13 of the Pandarian Union Convention on Cybersecurity and Personal Data Protection lays down 6 principles of data protection. Your Excellencies, permit me, in replying to their submission, guide this court on Principle 1 and Principle 2. Principle 1 is on consent and legitimacy of personal data. Your Excellency, we acknowledge that consent is the cornerstone of personal data processing and is the ultimate test of a legitimate personal data processing. Your Excellency, in relation to the data allegedly obtained from government records, the Republic of Zangi will not have needed to obtain consent. It had a duty to act promptly and decisively to safeguard national security. But Your Excellencies, for judicial notice, we submit that these actions were not done by the state of Zangi, and therefore they are only speculative. We deny such allegations.
What did the actions?
The actions in surveillance.
Who did the surveillance?
It is alleged that the government surveilled citizens and therefore obtained data without consent.
And you're saying that it was not done by the state of?
The state of Zangi.
So who did it?
There is no factual evidence that points it to the state of Zangi, and therefore we deny. It's upon the applicant now to prove.
But he said people disappeared one by one, and all the people that disappeared were found in police stations. So anonymous people surveyed and abducted people and dumped them in police stations.
Thank you, Your Excellency. I'll respond to your question and at the same time respond to the allegations of the applicant on the same. Your Excellency, the allegations that some of the abducted persons were found in police station is circumstantial evidence. And it is important, therefore, at this point, to point the general rule in the use of circumstantial evidence. Your Excellency, circumstantial evidence must be relevant. Circumstantial evidence must be considered with other evidence and must lead to a reasonable and legal conclusion about the fact in dispute. And finally, in such grave matters such as this, there should not be other logical conclusion. Your Excellency, on the fact that some of the abducted persons were found on police cells, there exists another logical reference on the same. It might be that upon being released by the abductors, the abductees went to the police station to report, and that's how they were found within the police cells. And therefore, Your Excellencies, that circumstantial evidence fails the test.
So just to understand your argument, the government did not collect biometrics. The government did not collect DNA. So what is your argument on consent? Just take me back to your argument on consent.
Your Excellency, we were acknowledging that consent is not absolute, and we also submitted...
Not absolute for sensitive personal data?
Yes, Your Excellency, under Article 13, consent is not absolute. It can be waived for national security interest and public order. But our submission is that this action was not done by the government of Zangi. And therefore, the question of consent is neither here nor there.
Counsel, you know this tribunal might be trying to protect you because it is alleged that your government was abducting people. If you're denying, and after this court you're abducted, who will help you? So this tribunal might just be helping you, okay? So please tell us the truth. Did your government abduct people? Because if you disappear, then we can't help you. Now, question. You agree that you surveilled and collected data, correct? But you're saying that consent was not necessary. That's what you said. What did you say?
I said that this court should note that the respondent denies the allegation of surveillance.
So you didn't did you collect data?
No, no data was collected.
So what happened?
Your Excellencies, there are anonymous sources, speculations that data was being collected by the government, that the government was conducting surveillance, that the government was obtaining data from the abductees. But Your Excellencies, there is no evidence that clearly point these actions to the state of Zangi as demanded by Article 4 and Article 8 of the ILC draft articles on responsibility of states for wrongful acts. And therefore, these actions fails the attribution test.
Did you arrest people in the protest?
Yes, Your Excellencies, people were arrested.
And you subsequently released them?
Yes, Your Excellencies, for example, Mr. Mwana Mwengi was released on bail.
And did you take their personal data during the arrest?
Your Excellency, under the fact pattern, there was no data that was collected during the arrest.
Okay, proceed.
Your Excellency, seeing that I have 1 minute, therefore I'll seek to close. Your Excellency, actions and... As
the state?
Your Excellency, yes.
Did you investigate? And what was your findings in the investigation?
The Inspector General of Police alluded that they are working with IPOA, especially on the question of rogue police officers. So there is investigation.
So are you now saying it's rogue police officers who abducted people?
No. Some of the...
Who then?
So who then?
Your Excellency, the question of abduction, we maintain that it was not done by the respondent state. On now the question on the rogue police officers, the Inspector General of Police intimated that it is working with the IPOA now to deal with rogue police officers who are violent against the protesters.
Let me just finish. My concern is on this abduction. Now, you understand it's the duty of the state to ensure the security and protection of all individuals. And so if the state didn't do it, it is duty to investigate and arrest those responsible. So you are admitting here, as the counsel for the state, there were abductions. You are telling us you did nothing about them, and you have not arrested the people who did the abductions. So then the easy finding for this court to make is, you are responsible for failing to arrest those who involved and failing to protect the citizens. Is that correct, the correct position? That's a yes.
No, Your Excellency.
Okay, thank you.
Counsel, if I may take you back a bit, if I remember correctly, you mentioned that violence by the police was directed to violent protesters, right? How then do we explain under paragraph 26 that the military lodged rubber bullets at some media house vans that varied journalists, as well as their filming equipment destroyed?
Your Excellency, on the same paragraph 26, the police were using tear gas canisters and water cannons until when protesters turned violent. They used stones against the police officers. It is important also to note that Zangi is a growing nation, and therefore the number of protesters outnumbers the number of police. And therefore, with such violence, the police have a default duty first to protect their own lives. And therefore, that's when the rubber bullets were used.
Against journalists?
Your Excellencies, it is unfortunate that some journalists were injured, but Your Excellencies, there was no intention on the part of the police. We note in paragraph 7 of the fact pattern that Zangi is a nation desiring to build a world-class legal system. It has ratified all the major instruments of human rights, and therefore this demonstrates its utmost good intention to guarantee its citizens of all the universally accepted human rights.
So when, were live bullets used at any point?
Your Excellencies, rubber bullets were used. There is no live bullet.
You sure?
Counsel, when you're still on your feet, you mention in your fact pattern about the military. What was the need to invoke the services of the military?
Your Excellencies, as alluded earlier, the number of police is far outnumbered by the number of protesters. Therefore, it was, and also with the intelligence that there was violent protests, there was a reasonable belief that the national security of Zangi was threatened. And this warranted, therefore, to call the military to support the police in restoring public order.
Do you have any authority that you could cite to substantiate invoking the use of military?
Your Excellency, the question of using the military within the state is within the constitution of the state. In the fact pattern, we are not guided on which laws Zangi is. We do not know which country Zangi is in order to invoke the laws within Zangi.
Counsel, let me just take you back to my question. Paragraph 26, it says that it is then that police officers were seen firing bullets at the protesters. This led to the death of 24 civilians. So is it still your position that live bullets were not used?
Your Excellency, rubber bullets were used, and rubber bullets caused 24 deaths. We admit that. No live bullets.
No live bullets.
Counsel, just as you said, as you sit down, some members of the public are outraged by your lack of emotions. It seems to you that 24 people dying is nothing. You mentioned mere human rights. So how do you respond to the people who think you are insensitive to, the deaths and the catastrophic things that happened?
Your Excellency, I wish to take back my words on mere human rights. Human rights are important to every person.
So there are grave violations that you've done?
Your Excellency, we have submitted that the actions of the respondent were warranted for restoring public order and national security, which now is permitted under the Siracusa principle on limitations of right, including the very right to life.
Very well, Counsel. In the interest of time, we allow next Counsel.
Greetings, members of the bench. May it please this honorable court, as earlier introduced by my co-counsel, my name is Wanjiku Kimani, second counsel for the respondents in this matter. I will be addressing this court on issue 3 and issue 4. With the permission of the bench, I seek to proceed. The Republic of Zangi, hearing the respondent in this matter, violated the intellectual property regulations of the Kingdom of Rahada, the applicants in this matter. That these works had already expired. On to the first limb of my argument, that the Republic of Zangi, hearing the respondent in this matter, merely used that which was in the public domain. Article 7 of the Berne Convention provides that copyrights will last during the lifetime of the author and not later than 50 years after his or her death. In our present case, Your Excellencies, under paragraph 29 of the fact pattern, General Moot was indeed the author of these blueprints, but he sadly died 52 years ago. In strict application of Article 7 of the Berne Convention, this surpasses the protection time provided for in this statute, and therefore, the applicants, the respondents in this matter do submit that the Republic of Zangi merely used that which was already in the public domain.
The applicant's main argument is the author of that copyright is not General Mahmoud, but the state, because he was commissioned to do the same. So the 50-year rule does not apply, if I follow the arguments properly. What will be a response to that?
Thank you, Your Excellency. Without prejudice to my argument on the issue of the lapse of the copyrights by General Mahmoud, the doctrine that the applicants relied upon, as a general principle in this doctrine, commissioned works by the government also do have an expiry time. They also expire 50 years after publication, Your Excellencies. And it is the respondent submissions that...
Just a minute. At the back there, can we kindly have order? For her sake. Kindly. You can proceed.
Thank you. As I was saying, these works that had been contracted by the Kingdom of Rahada, hearing the applicant in this matter, had already expired. And this takes me back to my earlier argument that the Republic of Zangi merely used that which was already in the public domain. The East Pandarian Community Intellectual Property Policy provides for public domain to include works that do not fall for protection under any intellectual property title and are thus available for use by the public. Your Excellencies, intellectual property is about protecting rights, but where the law gives no rights, there can be no violation. The applicant's speculation on the Republic of Zangi hearing the respondent that they violated the intellectual property regulations of the Kingdom of Rahada is false. As stated earlier, the Republic of Zangi merely used that which was already in the public domain. Therefore, the applicants have no enforceable rights in this matter, and therefore, it is the respondent's submission that the Republic of Zangi did not violate any intellectual property regulations of the Kingdom of Rahada. On to my fourth issue, on whether the Republic of Zangi violated Mwengi's right of access to information. Your Excellencies, the respondents in this matter do recognize that access to information is a shield for democracy, but it is not to be used as a sword to pierce the heart of national security. Your Excellencies, the applicants rightly quoted Article 9 of the Pandarian Charter on Human and People's Rights and Article 19.2 of the ICCPR, which provides for the right of access.
Counsel, sorry, let me just take you back to your previous argument. Under the Berne Convention, Article 7.1, it provides for the standard term for protection, right?
Yes.
When it says 50 years, is that minimum or maximum?
Thank you for that question. Article 7 provides that the copyrights will last during the lifetime of the author plus 50 years.
Yes.
In the respondent's understanding of this 50 years is the maximum period of time that this protection will last.
So does it mean after 50 years the protection lapses? Is that clearly provided in the Berne Convention? On the 50 years and 1 day, does that protection disappear?
It is the respondent's submission that this protection has expired. It is important
When did it expire?
Pardon?
Which date? Which date did it expire?
From our fact pattern.
Yes.
Under paragraph 29 of the fact pattern, we use General Mahmoud's lifespan as our point of reference.
I'm asking you, which date did it expire?
2 years ago.
And how do you arrive at that?
As I was stating, in our fact pattern, we use General Mahmoud's lifespan as our point of reference. General Mahmoud was the contractor, and he did so 52 years ago. This means that the 50 years has already lapsed, and therefore these works fall under the public domain.
Okay, proceed.
Thank you, Your Excellency. On to issue 4, on whether the Republic of Zangi violated Mwengi's right of access to information. As I stated earlier, The applicants in this matter have put forward that the Republic of Zangi violated Mwengi's right of access to information. However, the respondent's position in this matter is that the Republic of Zangi did not violate Mwengi's right of access to information. It is important to note that the right of access to information is not an absolute right. Secondly, it is important to note that the actions of the Republic of Zangi met the limitation test, that is, in the clear wording of Article 19.
Counsel, just a logical argument flowing from what your co-counsel had argued.
Yes.
So you prosecuted Mwenge, right?
Yes.
For alleged violations, but
Yes.
you did not prosecute a single rogue officer.
Yes.
Yeah. How do you marry those two? Why is your government so zealous in one hand and unbothered on the other?
Thank you. As my co-counsel stated earlier, the Inspector General clearly stated that they are working hand in hand with the Independent Policing Oversight Authority, that is the IPOA.
So did they work alongside IPOA to arrest and prosecute Mwenge?
No, Your Excellency.
Or did they work with other agencies, like Amnesty International, Article 19, to prosecute Mwenge?
Thank you for that.
Yes or no?
They did not work with
So
them.
why are they on one hand saying, we're working with IPOA, on the other hand, when it's Mwenge, they don't want to work with anyone?
Thank you. It is the respondent's submission that Mr. Mwengi was clearly identifiable as a citizen of the Republic of Zangi. In the protest that happened under paragraph 26 of the fact pattern, the police officers were many in the protest. Without prejudice to what my co-counsel stated, the presence of many police officers proved it hard to pinpoint the specific police officer.
So you're saying you're prosecuting someone, he was alone, but because there were so many people, it's hard to prosecute them. You don't know who did the wrong thing.
It is important to note that under paragraph 17 of the fact pattern, it is clear that Mr. Mwengi was the one who leaked the lease agreement. As I was saying earlier, without prejudice to what my co-counsel has stated, these police officers were many, and that's why the Inspector General is working hand in hand with the IPOA.
Why didn't you take less punitive measures, like come out and correct whatever assertions he made, come out and give clarifications? Why rush to arresting him?
Thank you. The action of arresting him falls under a crucial aspect of proportionality, which is a limitation that must be made.
So it is less punitive to arrest? So it is less punitive to arrest than to come out and give a clarification. Why is it so hard to give a clarification?
Thank you, Your Excellency. It is important to note the fact that institution of criminal proceedings, it is general knowledge that criminal proceedings are meant to deter occurrence of a particular action. The Republic of Zangi was merely deterring Mr. Mwengi from doing such a particular action again. The Republic
He had already leaked the list, correct?
Yes.
So how does prosecuting him deter him from leaking the list which he has already leaked?
Thank you. It is the position of the respondents in this matter that Mr. Mwengi's leak of the lease agreement was a violation of a special protocol that must be followed in publishing the private...
So let me ask about this lease.
Yes.
Is the lease a private document or a public document?
It is a public-private partnership agreement.
Come again. Is it a private document or a public document?
We do acknowledge that it is a public document since it involves crucial aspects of the Republic of Zambia.
So it is a public document?
Yes.
It is therefore not a state secret?
Yes.
It is not a state secret?
Yes.
Paragraph 28, he was charged with 2 counts of incitement and publishing of official secret documents.
Yes.
So you're saying it's not a state secret, it's a public document. Yes. But you are charging him in court for leaking a secret document, publishing a secret document.
Yes. That's the position, Your Excellency. The basis of doing this by the actions of the respondents we wish to present that there is a special protocol that is to be followed in publishing such agreements. The Republic of Zangi, despite the fact that we do not know the laws that provide for such protocol, the Republic of Zangi, like any other responsible state, has a special protocol in releasing.
And by this protocol,
information.
you mean that the list would ultimately be published through the National Assembly only after they have succeeded in drafting and composing the list. That is what you mean by the protocol.
Yes.
So my question is,
Yeah.
what prejudice did the state suffer because he leaked the document?
Thank you for that question. We do recognize that Mr. Mwengi leaked the lease agreement, but the result of this was seen under paragraph 19 of the fact pattern. He planned for peaceful protest. Your Excellencies, these peaceful protests were only termed to be peaceful on the surface. The reality is what happened under paragraph 26 of the fact pattern.
So the protests were because of the lease?
Yes.
But paragraph 19 doesn't say that.
Under paragraph 18 of the fact pattern, Mr. Mwengi organized for nationwide protest after the leak of the lease agreement. Under paragraph 19, the clear wording of it is that the protests were meant to be peaceful. And that is the submission of the respondent in this matter, that the protests were meant to be peaceful on the surface. But
So, and what I'm trying to understand, is the issue the protests, him planning the protests, or is the issue the lease?
the issue is the lease which led to the protest.
So you're saying, if the lease was not leaked, there will be no protests?
That is the position of the respondents.
But there are protests that had already happened even before the lease came, the question of the lease came.
Yes. It is important to note that there were different protests in this country. And under paragraph 18 of the fact pattern, that is under paragraph 19 of the fact pattern, after the leak of the lease agreement, under paragraph 18, this heightened and intensified the anger of the citizens of the Republic of Zangi. Under paragraph 19...
So the problem is that he leaked the lease and the lease angered people more.
Which led to him formulating protests which were as a result of the leak of the lease agreement. The respondent in this matter submits that, as I was stating earlier, there is a special protocol that is to be followed in publishing such agreements. Were it not for the rush of Mr. Mwengi, who tried to be the hero of a story that had not yet been written, all this would have been avoided. The respondents, Your Excellencies, since that my time is much spent, I wish to seek for 2 more minutes to wind up.
Yeah, proceed.
Thank you. The respondent in this matter do submit that the Republic of Zangi did not violate the freedom, the right of Mwengi, the right of access to information.
Council, in 1 minute, just talk about how you balance the question of public interest on this argument.
Thank you. We do recognize that the contracts involved crucial aspects of the Republic of Zangi. However, we still maintain that under paragraph 21 of the fact pattern, as per the Minister of Finance press statement, this information was eventually to be tabled to the National Assembly for deliberation, and whatever follows after that is that the public would know about the lease agreement. However, Mr. Mwengi merely rushed to do that which the government ought to have done, that the government was planning to do in a strategic manner. Therefore, it is the respondent's submission that the Republic of Zangi did not violate Mwengi's right of access to information. With the permission of the bench, I wish to present the prayers of the respondents.
No, it's all right. We'll read the prayers from your compromise, but I don't feel like you have answered the question on how you balance the public interest. Following from my fellow judge's question, this is a public document. It concerns matters of public interest, and so therefore, how do you balance or how do you argue public interest to favor you?
Thank you. As stated earlier, we do recognize that this is a matter of public interest. However, as the respondents, we still maintain that there was protocol to be observed in publishing this lease agreement. If there was any dispute about the lease agreement, as per the Minister of Finance press statement, this information would have eventually been made available to the public. An issue would have arisen after that, but Mr. Mwengi merely jumped and leaked the lease agreement, and therefore it is the submission of the respondent that the Republic of Zangi did not violate Mwengi's right of access to information.
Council, what is this protocol? Could you take me step by step? What would have happened if he did not leak this list to the public? What's the protocol that you're talking about?
Thank you, Your Excellency, for that question. As I had stated earlier, we do not know for a fact the laws of the Republic of Zangi. However, like any other responsible nation, Zangi has a clear protocol. First, I'll summarize it in 3 major steps. That first, we have the negotiation stage. This is between the contractors and the other party where the deliberations are made. Secondly, we have the tabling it to the National Assembly or the Parliament in the country in which this agreement is being held. And lastly, we have publicizing it to the National Gazette. That is where the members of the public learn about this lease agreement.
So he leaked it before even negotiations were conducted?
Pardon?
Did Mwengi leak this lease even before your 3-step protocol was observed?
Yes, he did.
Okay.
With that answered, I wish to thank this court for its time and refer the court to our written submissions for the prayers. Thank you.
Very well. Counsel for the applicant. 2 minutes for rebuttal.
May it please this court. Once again, my name is Lachelle Mwindi, counsel for the applicants, here to read the rebuttals. The respondent has insisted that the protection of original blueprints have expired. The applicant asserts that the copyright rights have already been transferred to the Kingdom of Rahada, and therefore the protection subsists as long as the Kingdom of Rahada stands. Article 7.1 of the Berne Convention is a general provision which provides a minimum of 50 years protection. A reading of Article 7.6 of the Berne Convention gives room for extension of the timeline. The counsel for the respondent has passionately submitted that they are not responsible for the targeted surveillance. However, paragraph 9 shows that the government had allocated money to cater for the surveilling of online social media platforms. Then this raises the question: why would you admit on having intentions to conduct surveillance and then later deny on the same? The respondent has further stated that there were intentions to table the lease agreement before the National Assembly. However, it is clear from the facts patent that the National Assembly has a tendency of ignoring public views. So what is the guarantee that the public interest in this, when the tabling occurs, will be considered? I rest my submissions and cede the floor back to the bench for further directions.
Your Excellency, on a star rebuttal, Council has raised rebuttal on points of fact. The rule is that rebuttals are raised on a point of law. We invite this court to dismiss this application.
We take notice of that, counsel. With that in mind, I wish to invite the bench to make brief remarks before we adjourn the court.
Thank you to all the participants. It has been wonderful and an honor to judge you, those ones who have made it to the finals. I appreciate you for taking time to do the preparations and also for doing the presentations with passion. For all the other participants, I also appreciate you for taking effort. I usually say that if you came here to compete and then you have already lost. But if you came here to if you came here to participate and learn, and then you have already won. If you came here to compete, you have lost. But if you came here to learn, you have won. That statement will assist you one day here. So for those who didn't make it, just know that you are the winners. For those who are in the finals, congratulations, and to the team that will win, you deserved it, whoever the team is. Otherwise, keep up the good spirit. Take this as an opportunity to understand matters of human rights, to understand matters of East African community law, so that the next time when you will appear for an interview before the law firm or the organization that these judges work for, you will tell them, I have experience in East Africa community law, and you will quote to them Article 6D of the treaty, Article 7.2. That is how participating in these competitions assists you. And if anything is to encourage you, my learned senior here was once a judge in a moot court competition that I participated. And we are seated with him here. One day you will learn the story, and I was reminding him of how me participating in that competition and he saw us participating made him to fund a certain trip I had. I had a certain trip to go to do a summer school in Switzerland, and I didn't have funding. He single-handedly assisted me to fundraise in 2019. That trip changed my entire life up to today. So do not take it for granted. And this I say especially for somebody who is seated there thinking that they lost. Take this opportunity, interact with these people, get their cards. You never know where it will assist you. I am seated here today with him, asking questions with him, and you see how an honor it is. So I wish you all the best. And thank you. It has been an honor.
Good evening, how are you? Yes, so for those who are thinking that I'm young, you can confirm from that I'm actually very old. I can tell you for a fact that the last time I did a moot court like this in uni was more than 10 years ago. Okay? And the first moot court that I did was the All Kenyan Moot Court competition. It was the first external moot court I did, and then I ended up being the best oralist in the country. And I was so surprised. I was like, me, of all people. And so I accidentally got into mooting because I won in the first ever moot court I did. And many years later, now I have a firm. This is my firm, FKC Legal. We do something entirely different now. I spent many years of my life in disputes. I even, in fact, later on proceeded to do a master's in disputes, but now I do something totally different. But I can tell you for a fact that the things that I learned in the moot court have been instrumental to date in what I do, because they have taught me communication, they have taught me how to speak to people, but most importantly, they have taught me how to persuade and convince people. And now I am purely in investment, but every single day I talk to clients. And because I was a mooter, I'm able to persuade clients to pay fees. I'm able to persuade people on the other side to agree into negotiations for my clients. And so the point that I'm making is that sometimes when you're in law school, you think, but me, I want to be a commercial lawyer. Me, I want to be an in-house lawyer, so there is no point of doing moot court. That is the biggest myth that ever walked in law school. Because I was told by my professor many years ago that you see, as a law student, you must imagine all these things. You must imagine yourself as a workman who has a toolbox. And so when you go into a place, you must open your toolbox and things must overflow. For example, if you call a plumber to your house today, then they come, they open their toolbox and there's only one thing, a spanner. You call another plumber, he comes, he opens, there's things all over the place. Who in your mind do you think has more experience? It's the second one, right? So moot court, you have to think of things in law school like that. You're just adding things to your suitcase, and then ultimately you'll open and you can decide, do I use a spanner? Do I use a pliers? What do I use? So think of moot court in that way. And don't limit your mind and think, I don't want to be a litigator, I'm not going to do moot courts. Now I do something totally different, but the experience that I had in moot court is important. Lastly, for you sitting there, the people at the back, and if you didn't take part in the moot court, I want to encourage you to take part, okay? I want this to be an inspiration for you, because if you ask them, they're very happy. When you think we are grilling them, they're actually very happy, because they know that engaging with the judges is a good thing. So please take part. And for the people who are sitting here in front, regardless of how it goes, you are the ultimate winners. The victory belongs to you. There is a quote. I want to read a quote for you. I think it's a speech which is called "The Man in the Arena." Do you know it? The Man in the Arena. The part that I'm concerned is that it says the credit belongs to the man who is actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs, who comes short again and again, because there is no effort without error or shortcoming, but who does not actually strive to do the deeds, who knows great enthusiasm and great devotions. And so at the end of the day, victory belongs to you. Victory belongs to you who is in the arena, who fights, who fails, who gets injured, whose face is marred by dust. Victory doesn't belong to the people sitting in the back and wondering why you're wasting your time, okay? And I promise you there is a great reward in the end. Thank you.
Good afternoon once more. My name is Stella Nekesa again. And first of all, I would like to congratulate the two teams for this far. I believe it's no mean feat. You both have done so well as the rest of the teams that were eliminated previously. Every day is a learning day, and we have learned a lot. Personally, I've learned a lot from the two teams as well as the other mooters. For the winning team, congratulations. For the runners-up, you have done exemplary well, and all the best as you go ahead. I would like to also thank you for participating, thank all the participants for participating this far, and wish you the best. Thank you.
Good evening, everyone. It has indeed been a long day, a long journey. So my name is Charlene Wawera, an advocate of the High Court of Kenya. I wear many hats. I am a data protection enthusiast, a data protection specialist. That is why my questions were very specific to data protection, as you would have noticed. I also am a mediator also, and I'm employed. Yeah. Thank you very much for all of you for being here at this particular moment. It is currently a few minutes to 7. You have really been resilient in sitting here. Thank you very much. Congratulations to all teams. You have exemplary arguments. The participants who appeared before me, I can see some familiar faces in the crowd. You have very, very good arguments. I have very much hope in the future of this profession, and I wish you all the very best. Congratulations to the two teams that made it to the finals. You have had very good arguments, very meticulous points of facts, points of law. You know your arguments very well. I'm sure once we retreat to tally the marks, it will be a very tight race between the two teams. So congratulations. May the best team win. I wish you all the very best. Yeah, and as you go along with your studies, and as maybe probably you're almost finishing your law school, I wish you the very best as you advance. And in 2-3 years, we will be welcoming you to this side. Well, we will be welcoming you to the profession, and we will be here to guide you, because I believe that mentorship and guidance to the younger people at the bar, you know, the younger professions, the younger advocates, is really, really important. And that is why I even showed up today here, because I believe that I can offer guidance, offer advice, offer whatever you need. I think there's somebody I was talking to, I can't see her right now, but I was telling her that yes, KSL is a bit gruesome, because I'm fairly new into the profession. My seniors here are very old. Me, I'm relatively new, so I can remember the experiences at the Kenya School of Law. But I was telling her it is possible. It is not as gruesome as it is, and you will be able to make it. If we did it, you'll be able to do it as well. So thank you very much. I hope to see you again. I hope to interact with you, and may God bless you. Thank you.
Wow, that's great. We don't want to turn the bench into speech making. We've done well. Congratulations. We are proud of you guys. We welcome you to practice very soon. As you see, we are so diverse, despite the fact that we come from the law fraternity. Look at what you have done not from a narrow perspective, but see how you can use your skills and knowledge to make a difference in society. We are in the era of even content creation. Use what you've done to just make people aware, to create awareness. Use your TikTok to make a difference. So don't limit yourself and wait the day you'll be in the courts to make your voice heard. Otherwise, as far as the Moot Court is concerned, you allow the bench to retire, deliberate, and make a final judgment. But as it stands, the Moot Court is adjourned.